Good afternoon, everybody. My name is Rob Lindsay. I want to welcome you here today. Thank you for coming out. As you can see by looking around, you can see I would say it would be fair to say that we underestimated what the turnout was going to be here today. Hello, but thank you, ma'am. But anyway, we're glad that you're here. Yes? We can't hear you. You can't hear me back there? Well, okay, unfortunately, I don't have a mic, so I'm just going to have to speak very... You can't hear me, really? Okay, well, I'm sorry, but this is the facility that we have and the facility that we're just going to have to work in today. This presentation is being taped, and so it will be available online for anybody to view afterwards. So I'm just going to have to speak as loud as I can. I feel like I'm pretty close to yelling.
Come to the middle of the room.
Okay, that's fair. Okay. My intent was to wait a few more minutes because we still have people coming in. No, I understand that, ma'am. But we are seeing fewer people. But I'll just go ahead. I'll start talking and we'll get this thing going.
Yeah.
Okay. In the interest of everybody else's schedule. Again, my name is Rob Lindsay. I'm the Water Programs Manager out here. And I'd like to take a moment. I'm going to introduce other people who are going to be talking with you today. Starting right here, this is our building and planning, or actually our building department director, Randy Bissa. Keith Stoffel with the Washington State Department of Ecology. He's the section lead for the water resource section. This is Mike Hermanson. He's a water resources specialist, actually water resources manager now for Spokane County. He works with me on watershed planning issues. And then in support of us today, we have two of our experts, our consultant experts, Carl Einberger and Dan Haller from Aspect Consulting and Engineering. They've been helping us with addressing the challenges that Spokane County has encountered with the Hirst decision. So I'm going to start with a brief introduction. Spokane County has been engaged in watershed planning activities since 2000, and mostly through the support of the Washington State Department of Ecology, and we've been conducting watershed planning activities in watersheds throughout the county. It was primarily a theoretical exercise. There was a lot of discussion around the table about how to manage water resources. One of those topics was permit exempt wells. As I said before, it was primarily a theoretical discussion. It became practical in October of 2016. And
Can we have more people stand up over there?
Sure.
Okay, there's a whole bunch of people out there waiting.
Okay.
We're going to have a video screen that's going to be put out there.
Yeah, and soon we will have a video screen out there. But again, in October of 2016, the Washington State Supreme Court rendered what is known as the Hirst decision, which, as I'm sure virtually all of you in the room are aware of in one way or another.
Not at all.
Not at all. Okay, the Hirst decision, basically, through the, and we're going to have it as part of our presentation, it will describe it, but in short, the Hirst decision instructs that counties, as a part of the Growth Management Act, need to determine whether or not water is legally available as part of the building permit process. Okay, and also they made it very clear that as part of that building permit process, counties are responsible to ensure that new uses, that i.e. permit exempt wells, will not impair existing uses. Okay, and it's basically what it is from my interpretation, it's a matter of treating permit exempt wells in domestic settings the same way that we treat water rights, permitted water rights. That is, first in time is first in right, and that new uses cannot impair existing uses. And that's the challenge that Spokane County has been dealing with. And in the case of the Little Spokane River Valley, where there's an in-stream flow rule in place on that river that dates back to 1976, and in that time, in the last 40 years, the river has failed to achieve those flows in about 30 of those years. The basin is essentially closed. And if you were trying to get a water right in the Little Spokane River Basin, since as far back as the mid-70s, you're still waiting. You know exactly what I'm talking about. You can't get a permitted water right in the Little Spokane River Basin. So what this has basically done is it's pulled permit exempt users into the same pool as those who would be applying for water rights. So we're going to be having a presentation by Dan and by Carl, which is going to go through this, and then we're going to have a question and answer period after that. And all I would ask is number one, keep it civil. Number two, please, higher level questions about specific parcels, specific situations. I encourage you to come and talk to us later. Mike and I, I'm not exaggerating, we probably both take a half dozen calls a day from people who have specific questions about specific properties. So we're not going to be able to answer your specific question in this open setting, but we will be available to deal with questions after that. So without any further ado, I'm going to turn it over to Dan Haller with Aspect Consulting. Thank you.
Well, good evening, folks. I'm going to start this presentation off with some basic information about water rights so that hopefully we all have the same kind of common understanding of what we're working with here. But I'd like to start with hopefully a softball question. If you guys could all get building permits today for your parcels and pay a fee and never have to think about water rights again, and the fee was reasonable, how many of you would do that today? I would do that. That's what we're trying to get to, okay? Water rights are hard, and I'm going to give you some sense of how hard they are, but frankly, you're getting the elementary school version of what we're going to show today. They're a lot harder than even we're going to talk about, but we're trying to get to a point where you don't have to be water right experts. The county's going to do that, and we're going to try to make that as simple and as affordable as we can in reaction to the case that Rob just described. So I'm going to start with some of this water right fundamental, water right 101 information. Mike's going to go through a conversation around how the county has started to adapt to the new world. Carl's going to talk about how the groundwater and the surface water connect and why that matters. And then I'm going to come back and tell you where we're going and hopefully where we'll be just 7 or so months from now towards the end of the year, where we will have a functional bank operating. So the first thing is, what is a water right? Okay, a water right is a legal authorization to use water. It's a type of a property right. It's a use-based property right. Many of you probably have heard the phrase, the water goes with the land. Okay, it's a use-based property right. Why do we have them? Well, we have water rights because people, our great-grandfathers, were fighting about water 100 years or so ago. Okay, so the whole premise here was that there wasn't enough, particularly in times of drought, to go around, and so we needed a system where during times of shortage, people could decide who got the water and who didn't get the water. Okay? The notion about this was that it's a public resource. It's all of our water. It's not my water, it's not her water, it's not his water. It's all of our water collectively. It's a public resource. Okay? This concept predates Washington as a state. It came from England initially, and then became codified in our territorial laws, and then ultimately in our state laws as well. The notion that water is a natural resource for the public. It's not owned. It can be used, but it's this use-based property right. In 1891, the Washington The legislature defined the prior appropriation doctrine. Okay, you've probably heard the term first in time is first in right. Rob mentioned this as well. That means that essentially whoever was here first, whoever has the oldest priority date, the oldest water right, they get to use their water in its entirety in a time of shortage to the exclusion of anybody who's junior or who came after them. Okay? And the earliest way that you did this was you literally nailed a notice on a tree next to the creek where you started to divert water, and then you went down to the county courthouse and you entered it into a book of water rights. So people knew how much you were taking, when you started, and where your diversion was. That was the first way you got a water right in Washington State. The problem was, at that time, there was really no one in charge. The people who filed those appropriations, filed those notices, would claim many more times the amount of water than the creek could even produce. And there was no regulatory agency.
You need to speak louder so that the 50 or so people that are out here that can hear you. There's just no way that we can even hear what you're saying.
I appreciate that, ma'am, and I'm going to try to make my volume as loud as I can. It is being videotaped, and we are going to have a second screen, so we're going to do our best we can. But thank you for that comment.
Why don't you come down to this point and they can hear you and the people behind you can hear you.
Great suggestion. If the video person can help follow so that can work out as well. So there was no one in charge of water rights at the time. So that was a big problem that the legislature was trying to solve. Go ahead, Carl. So in 1917, they adopted the first surface water code. Okay, so we're sitting here in 2017, 100 years later, the 100-year anniversary of the water code. And this established the first permit system for water rights that existed in the state. At that time, people weren't even really using groundwater wells, and so there was really no mention of groundwater rights at the time. Okay? This included putting that law, first in time is first in right, into the statutes. It created this permit system where if you wanted to divert water, you had to apply to the state to do it. And it provided a process for adjudicating water rights in times when folks had water disputes. Okay, so it set these laws into place. Go ahead, Carl. So I'm going to introduce three pieces of paper that you may have heard of that we're going to talk about. Go ahead. The first is an application. So if you want a water right in this state, you have to file an application with the state. It usually costs you about $50. It's about 5 pages long, and you fill out these things. Where are you going to take your water? How much are you going to take? What are you going to use it for? What's your parcel that you're going to put it on? The application is just a dream. It's a goal. It doesn't give you the right to do anything other than it's a request. Go ahead. Eventually, Ecology will issue you a permit if they find that certain tests are made. And the permit is the permission to use that water and go build your project. That could be go build some houses, go plant some hay, go water some stock. Whatever your dream was in your application, that's what your permit will reflect. Go ahead, Carl. If you do all the things that the permit says, if you build your diversion, you build your houses, you plant your hay, you do all those things, and you tell Ecology, I did those things, then you get a certificate. Okay? Now, usually, that's the place where people think, I'm done. And you may have a certificate for your property. But a certificate is only a snapshot in time of what your water right is. Because remember, your water right is a use-based water right. You have to keep using it in order for it to stay as big as it once was. Many of you have probably heard the term relinquishment, or use it or lose it. In this state, if you don't use your water at least once every 5 years, or qualify for one of 22 exemptions, which are essentially good reasons you don't have to use your water, then your certificate can go down. It can be forfeited. Even though the piece of paper is there, it can get smaller over time. Okay, go ahead. So that's the paper we're talking about. Back to the history lesson. Now we fast forward to the groundwater code. Remember, we were at 1917. That's the surface water code. Well, now we have 25, 30 years later, people start drilling wells. And the same problems the legislature faced in 1917 with people fighting about surface water began to emerge as people began to fight about groundwater. Wells were interfering with each other. People were fighting about how much water there was available underground. And so the legislature created the groundwater code. And it mirrors the surface water code in many respects. It has the same permit system that the surface water uses. So application, permit, certificate, that same process is used. However, and this is where we start to get into the issues Rob was talking about with the Hirst decision, it created an exemption for groundwater uses. The notion was that for some small uses, it wasn't worth folks' time or the state agency's time to try to regulate very small uses. And so they were exempt from the permit process. You didn't have to go through that application process I described. So what is the permit exemption? Okay, the permit exemption is a cumulative amount of water for your project that meets these criteria. You can have single or group domestic use of 5,000 gallons per day from a well. And you can have 5,000 gallons per day for industrial uses. And you can have irrigation of a half acre of non-commercial lawn or garden. And you can have however much water you need to water stock. Okay? And it probably took 5 Supreme Court cases to figure all this stuff out, but that's the original exemption that was codified by the legislature in 1945 and has essentially remained unchanged over the last 70 years. Okay? The fact that the groundwater, that your well is exempt from permitting does not mean it's exempt from the other elements of the water code. What do I mean by that? It still has a priority date. First in time is still first in right. So people who drilled their wells and used them 40 years ago are more senior than those that drill today. So in a time of shortage, those older wells would be entitled to first use of that water. Okay? You still can't impair existing rights. If my well's here and this young woman's well's here, I can't interfere with her older well if I drill a well right next to her. All those same principles of the water code still matter. It just means you don't have to go to the Department of Ecology, pay your $50 fee, and go through that application process I was talking about. Okay, so this is a snapshot of all the other crazy stuff that goes on in the water code. It's really complex. The legislature has added laws every few years saying, okay, in this fact pattern you got to do this, and in this fact pattern you got to do this. And I'm not going to go through all of these things, but some of these may apply to you and some may not. Okay, and you're probably going to need some help to figure that out eventually. The ones that I want to highlight are the first and the third bullet, which is minimum in-stream flows. Okay, because that's where this Hirst decision really affected the Little Spokane Basin. It's the intersection between people who want or have groundwater wells and when there is an adopted in-stream flow that is intended to protect the creek. Okay, that's what the conflict we're here today is about. What is an in-stream flow? It's another type of water right. It is a water right that's adopted in rule. It has a priority date based on when it's adopted. The intent of that in-stream flow water right is to provide a minimum amount of water in the stream necessary for fish. Okay? That's what the purpose of it is. And so when it is established as a water right, it means that anybody who is senior to that is unaffected by the in-stream flow. So if you have a well that predates the in-stream flow rule, you're senior, first in time is first in right. It doesn't matter what the water in the creek is doing. But if you're junior to it, it was there first, and therefore it can affect your use in a time of shortage. Go ahead. I just said this. Go ahead. Okay. How did we get here? How did we end up with a in-stream flow rule on the Little Spokane Basin? Well, the legislature passed laws that said in areas of water shortages, we can't just take all the water from the river. There's got to be some left for fish. So state agency, ecology, go figure out where these challenges are and adopt those rules. And in this basin, in the Little Spokane Basin, the state did that with a panel of a citizens advisory group to help inform them about what the levels should be in the creeks and what the values of the Little Spokane Basin are. And you'll see a number of priority values up there that citizens committee and the state agreed were important for the Little Spokane Basin. And basically, if you look at the last bullet, it says that any new uses after the in-stream flow, depending on drought conditions, will need to curtail. We'll need to stop using water because, again, first in time is first in right. You should leave here today with that burned in your skull. That is the law of the land in Washington. So if there's a use after 1976, when the in-stream flow rule was created, then it's junior and is at risk to being curtailed when the in-stream flow is not met. Go ahead, Mike.
I do want to bring up that people that have existing wells and are using water will not get curtailed. There is no effort at all to go and tell people that have existing wells to go shut their water off when the flow goes down below a certain level. Just to make that clear to everybody so that nobody walks away thinking, oh no, I drilled my well in 1980. Am I going to get shut off? Nobody is going to be shut off. There's no intention of shutting domestic users off whatsoever. This is something going forward is the issue.
So that's a good point. The Hirst decision is about issuance of new building permits and what the county's responsibility is when it has to do that action. Okay, so that's the thrust of what we're talking about here. I mentioned a bunch of Supreme Court cases that interpreted the exemption. There's a list of them here. This is a very litigious scenario where, because in most cases the exemption was the only available source of water for folks to use for their property, there was a lot of question about what it really meant. And so it took a number of cases to try to interpret that. Go ahead, Carl. The reason for that is in the early 90s, ecology stopped issuing water rights in most basins. There's a number of reasons for that, including the listing of a number of salmon under the Endangered Species Act. So in response, there was this greater reliance on the permit exemption. And in response to that greater reliance, some folks thought that the permit exemption was being abused, and so they litigated to try to understand, well, is that fact pattern okay, or is it not okay? And that's what spawned all these Supreme Court decisions. So I'm going to give you a sense of a timeline of how the world has changed with respect to the exemption. So before 1945, there wasn't a groundwater code at all. You didn't need any permission to use a well. Okay? After 1945, you needed a permit from the state, but not for small exempt uses. Okay? Then in 1971, the legislature started allowing the adoption of in-stream flow rules, which then said that in-stream flows generally only create impacts with surface water and groundwater that directly impacts surface water. So if a well is very close to a river, then there might be presumed impacts, but if it was very far away, not the case. Then after 2001, the Postuma decision came out. And in Postuma, the Supreme Court said, well, really, all groundwater withdrawals probably impact surface water somewhere. It's just a question of how long in time before those impacts show up. Go ahead. Then in 2002, in the Campbell and Gwynn decision, the court said, well, yes, people are entitled to an exemption, but the exemption is not tied to the well. The exemption is tied to the project. In other words, if you have a single project, you get an exemption for it. But it doesn't matter if you supply it with one well or 10 wells. You only get one exempt use. This was a scenario where folks were serially trying to use more and more wells to get more and more exemptions when they probably should have just gotten a permit instead. After 2011, in the Kittitas decision, it clarified that counties had to evaluate whether water is legally available before issuing a building permit. But they could still work with ecology to make that determination. And then this decision that came out that Rob described, the Hirst decision, went a step further and said that the county has an independent responsibility that is more expansive or different than ecology under the Growth Management Act to independently determine whether water is legally available. They couldn't simply rely on ecology's 20-year-old rules in some cases on that determination. They had to make a fresh, independent determination. Okay, so that's the foundation of some basic information on the water code. Carl's going to talk now about the Hirst decision. Oh, excuse me. Mike's going to talk about the Hirst decision and how the county over the last few months has been adapting to that.
Like Rob said, my name is Mike Hermanson, and I'm will be the new Water Resources Manager for Spokane County. And I'm going to talk a little bit about how Spokane County, usually a land use decision-making body, got into the water business. So before 2011, and people might be familiar with this. To get a building permit, all you needed to do was drill a well and show that water was physically there. You would get water and that you could actually drink it. It didn't have nitrates and it didn't have bacteria in it. With the Kittitas decision, as Dan said, the court said, well, it's not just enough to look at whether water is physically available. You need to look at whether water is legally available. Because if someone can shut you off, then that's not a suitable source of water for your building. But they also said in that decision that the county can rely on ecology to give them input as to whether water is legally available. So our position was, well, if ecology tells us that water is not legally available, then we'll do something. But if we don't hear anything, no news is good news, and we just keep going. But then the Hirst decision comes, and it was very clear in saying that the Growth Management Act and the State Building Code requires the county to assure that water is both factually and legally available. And then, I believe, go to the next slide. It had this statement, which is pretty strong statement from the court about what counties need to do. And it says, counties may not rely on ecology's inaction in failing to close a basin as a determination that water is presumptively available. So what that said basically is, well, if ecology's done nothing, that doesn't tell us anything. You need to go out and figure out if water is legally available. You need to do that determination aside from what ecology does. And so, under the State Building Code, RCW 1927-097, the county is required to establish that when we get a building permit, that there's a legal and physically available source of water for that building. And so, to do that, we developed an interim ordinance. And water supply is not managed on a political boundaries. It's managed on the watershed boundary basis. And so the legal availability question depends on where you're at in the county. Spokane County has 6 different watersheds and another different watershed management unit, which is the Spokane Valley Raptor and Prairie Aquifer. And so our ordinance had to address each one of those uniquely. In the Little Spokane watershed, we have an in-stream flow rule, and that really puts some constraints on the legal availability of water. And I'll go through that a little bit more. In the other management unit, the Spokane Valley Raptor and Prairie Aquifer, there are some other restrictions, but this restriction was actually a very recently enacted rule, and they foresaw the issues that are now occurring in the Little Spokane Basin and established a procedure whereby new exempt wells could be drilled. In the other areas of the county, there is no in-stream flow rule, but it was directly in the decision that counties must establish that a new use will not impair a senior water right. And so we had to do some sort of evaluation to determine if, when you get this building permit and you start using water, are you going to impair an adjacent water user? In the area that's the Spokane Valley Rathdrum Prairie Aquifer, it's actually a groundwater management area, which is unique to water management in the state of Washington. Most management areas are actually based on surface water boundaries. But in that area, in essence, what the rule says is that there's no more water available in the Spokane River or the Spokane Valley Rathdrum Prairie Aquifer unless you have some way of offsetting your new use. And to offset that use, when they established the rule, the Department of Ecology bought a water right. So they bought a water right that was taking water from the aquifer. They purchased the water right and they stopped that water use. So then when they stop that water use, they have a credit in the bank, essentially. And then they're allowing people to get building permits and withdraw from that bank. And that's essentially how the Little Spokane will work when we get to that point. So the next. Now, in areas without an in-stream flow rule, we didn't need to worry about whether we were impacting the stream flow, which really simplifies things because there is actually water available to allocate. But we needed to ascertain whether when you are going to put in a new building, if you drill a well, but someone's been here for 20 years and they've got their well right over here, when I start pumping this well, is it going to take this person's water? And before it was just kind of, well, wait and see. If it happens, then this guy can sue this guy. Well, the Supreme Court basically said that's not good enough. You need to figure that out beforehand. And so we've established a procedure by which we can evaluate when one person has an existing well and one person wants to put it in over here. What is the, how far do they have to be before they're not going to impact this new user? And so that's where this ordinance comes in. And what we did was establish a setback distance. So a setback distance, similar to what you have to set back a well from a septic system. So the setback distance is based on some hydrogeologic analysis where we established you have a well over here, and then you have another well that's going to be a new well. When you start pumping a well, you get what's called a cone of depression. And so at a certain distance, you're right next to it. When you start pumping this one, it's going to affect this one. But as you get farther and farther away, that impact goes away. And so what we did was establish a setback distance. And we did it under some conservative assumptions. And we came up with, in a aquifer situation where impacts from a pumping well extend the greatest distance, that at 500 feet, we've established that we are comfortable in saying to the, when someone comes in and says you're not doing the right thing with your building code, we're comfortable in saying, no, we believe we are. Here's the analysis we did, and if you're 500 feet away, we feel like you're not going to impair the existing water user. But then that was the very first iteration of our ordinance. And then we refined it some more because depending on what kind of aquifer you're in, the setback distance can change. If you're in an aquifer that's sand and gravel, if you guys are familiar with the different types of aquifers, if you're closer, you can be closer to another well and you're not going to impact it. So the aquifer distance is dependent on what kind of aquifer you're in. And it's different sand and gravel, clay and silt aquifer, a bedrock aquifer, and a basalt aquifer.
Just one quick question. Because on site you have these shallow wetlands where you have bedrock within like 10 feet, you have the basalt outcrops. Doesn't that divide a tier approach?
Yeah, so that comes to the tier 3. So now we have one other one that we get to, and that is we couldn't account for every situation that's out there. We know we have scenarios out there. We've done a lot of hydrogeologic studies, and we might have a scenario where there's a person over here in an aquifer and over here, but there's this big mound of bedrock that just pokes right up. So we know that when this guy puts the well in over here, he's not going to impact this guy because there's big rocks in the middle of it. But we couldn't go out and map all of those and figure all those out, put in an ordinance. So we put a provision in the ordinance so that you can hire a hydrogeologist that would come out and say, well, in this situation, the 500 feet or the 200 feet isn't applicable because this is the scenario. We stopped pumping this guy, or there's situations out there where there are 2 layers of aquifer, and pumping on the top layer doesn't impact the bottom layer. So we did that by being able to bring in a hydrogeologic report that looks at the site-specific conditions. So, and then comes the WIRA 55. And as Dan was talking about with the Supreme Court decision, really boxed everybody in with when there's an in-stream flow rule. And it essentially said that when you have an in-stream flow rule and the river flows go below that level, that when you start pumping any well anywhere in the basin, that's going to by de facto impact that stream flow. In essence, that's what it says. And so in 55, our ordinance specifies that if you have a water right or certificate, then you can use that, and that you can base that for your building, new building permit. Also, if you're rebuilding something, you had a mobile home and you want to put a house on, well, you're just continuing an existing use, so that should be fine. But for a new building, there needs to be, if you don't have a water right and you don't have an existing building, then what do you do? And that's where we're going to kind of come into the water banking idea that is being used successfully in the Spokane Valley Rathrum Prairie Aquifer, and which we are developing for the Little Spokane. But how the water bank works and why all of this even has come to be has been a increased knowledge of the science of groundwater and surface water. And Carl from Aspect Consulting is going to discuss.
We got a question in here.
Oh, so you said if your building needs to be replaced, what if the well goes bad and you have to go?
It's all about the use. It's not about the well. So you can replace a well, you can deepen a well, you can do anything. When you've established the withdrawal and the use, when you're using water, you've established the right. And so you don't need, if you can, recondition the well, do whatever you want, hydrofracture it, anything. So. Yeah.
Surely you guys have data that could tell us what is the percentage of people in Spokane County that have actually had a legal.
We can't hear the question.
domestic well?
Right.
How many people have had a legal dispute?
What is the percentage?
There's been very few disputes over exempt well, and likely because the cost of bringing a lawsuit is a lot higher than drilling a new well. But unfortunately, that's really, this is all based on the court case of what the county has a responsibility to do under the law, and that's where we're at with what we need to do. And when the commissioners considered this, they looked, of course they have to implement state law correctly, and also if they don't do it, there's a risk of making decisions that are contrary to state law. And so that was the consideration that they took.
Are there any efforts challenging the Hirst decision?
There are, there's a Supreme Court decision, and so there's nowhere to go in state law and in the state court system. We did ask our attorney about someone, could someone take it to the federal Supreme Court? And the Hirst decision could not be appealed. It's run out of the timeline of being able to file a petition to take it to the federal Supreme Court if they wanted to. And so it's exhausted on that front. Maybe under another fact pattern it could be
Isn't there
brought.
something on the Senate that passed the House and it's going to the Senate? It's sitting on the desk right now.
Yeah, well, after we're done with all of this, we can kind of circle back and cover where the legislature at, because we've been really watching that very closely and trying to,
Yeah, folks, if folks could just hold their questions, there's some things we're still going to cover that may answer those questions, but we promise we'll have more time for questions at the end.
So, my name is Carl Einberger. I'm a hydrogeologist with Aspect. So, I'd like to talk to you about groundwater and surface water and how they're connected. Some of this goes back to things your kids learn in school, but I'm just going to go through some of this quickly. So how does your well up in Deer Park impact stream flows way down in the Little Spokane, and why? And the Postuma decision really fine-tuned that, unfortunately, in some ways, that even, the slightest impact, even if it's not measurable, matters under that case law. So, some conceptual hydrogeology. When the snow's gone, we've had a really good year this year. There's a lot of water in the system, but the snow is going to be gone in summer, but the river's still going to flow. Where does that come from? It comes from groundwater seeping into the river in the summertime. This is a great example of something your kids learn in school. The water cycle, you get precipitation. Some of that evaporates, gets used by plants. Some of it runs off in rivers directly, but a lot of it also goes into the ground and feeds the groundwater system, and it later discharges to surface water somewhere. Now, if you put a well in, you pump that, back one, Dan, that draws down the water table to some extent. And if you're close enough to a stream or even at some distance, you draw in water from that stream. So some of the water is not just coming from the aquifer system anymore, it can impact in-stream flows. And that's what we're dealing with here, and even more so because of the Hirst case. So how do we evaluate this? Well, we've collected well data, we look at the hydraulic properties, permeability, stream flow measurements, etc. And we can use mathematical groundwater modeling to estimate the effects of this. Right now, the county has received a grant, and there is a groundwater model being developed for the entire Little Spokane Basin. So that is in progress at the moment to help the county manage water issues, particularly in light of the Hirst decision. So why is hydraulic continuity important? For one thing, it's built into the state laws, and recognition that groundwater and surface water is connected is specifically called out. And then there's the recent case law, the Postuma case, which I just talked about. You don't have to be able to directly measure stream flow changes if there is other evidence through analysis that there would be some level of impact. Frankly, Postuma comes down to one molecule of impact. That's how strict that standard is. And with the Hirst case, now, as Mike and Dan have talked about, that has brought exempt wells into the fold to be considered for impairment on in-stream flows. So again, why is hydraulic continuity important? Well, if you wanted to get a new water right, and I'm not talking exempt, talking permitted, as Mike and Dan mentioned, you can't really get that anymore because of the in-stream flow standards, because your well would be subject to interruption when in-stream flows aren't met, so it wouldn't be a reliable water source. It's important for evaluating the impairment of your well on in-stream flows, and it really ties into how do you mitigate for that. And that right there is what the water bank is all about. It's about getting other water rights that already exist under state law and feeding the bank so that exempt well permits can come out of that and be used and solve this problem. So this is just another example of you pump a well, you draw down that water table, and you can induce stream depletion. And there's that hook that brings this situation to the forefront. And Mike also talked about well setback requirements. We assisted with the analysis to figure out that 500-foot distance through groundwater flow equations based on the type of rock that was there, et cetera. One of the things that you should know if you have concerns about a neighbor and impairment is your own well can't just be sipping from the top of the aquifer. It has to be deep enough. It has to be a reasonable development of the aquifer, and that is stated in law. And if your neighbor impacts your well so it drops by a foot or two, that's not enough to have a situation where you could really fight back to that. The county has selected 10 feet because that seems very reasonable under the circumstance. So that's what we're tying these setback requirements to, as Mike had talked about earlier. So mitigation suitability means that you're offsetting the effects of your pumping. And again, that ties in with why we're going down the path of a water bank. The water bank would be managed in terms of the actual consumptive use, not the total use from the water rights. And it would mitigate the in-stream flow effects that Hirst now leads the county to do. So with that, I'd like to turn it over to Dan. He's going to talk more about the actual water banking process that we're going through to resolve this issue for Spokane County in the River Spokane drainage.
So you've heard 3 presentations about what the problem is. So the last presentation is what the solution is. And I'm going to talk to you about water banking. And I'm going to use an analogy of a regular bank that everybody goes to every day to drive this point home. So let's say that every one of you had an exempt well, and that every one of your impacts on, so by analogy, every one of your exempt well impacts is $1 on the stream. Okay? There's about 200 people here. I would need to buy $200 worth of water right that's senior to the in-stream flow rule and deposit it in the water bank to cover all of you. And then every time you wanted your building permit, you'd come in, you'd pay your $1. That would offset the impact on the in-stream flow. That's conceptually what a water bank is. Actually, let's stay here. So a water bank, in this case, is going to be administered by the county. And what they're going to do is it coordinates or it positions sellers of water rights. Those are people, generally farms, for example, with buyers of water rights, in this case, exempt wells. And they can't, and this is all the red tape. This is all the permitting, the tracking, the reporting, the compliance, all those other functions necessary to do what a bank does, whether it reports to the federal government because it's FDIC insured. It's the same kind of principle. Go ahead. Water banking, it's really not all that new. It's kind of exploded onto the scene in the last 10 years or so, but there are a lot of water banks in Washington right now. Here are some that are either already established and running and have been running for a number of years, like Kinnitas County, for example, who was kind of first on the scene on this issue with exempt wells, or they're being developed and put into place. And it doesn't have to be a county. You have banks run by the state. You have, like Mike mentioned, with the Spokane Raft and Prairie Aquifer, you have banks run by irrigation districts, public utility districts, nonprofit organizations, and private entities. So there's a whole host of people who can provide that center banking function, but at its heart, it's trying to convert old water right from one use into a new use. Right? So why do we even need water banks? Traditionally, in fact, as part of the original Surface Water Code in 1917, there was always the ability to transfer water rights, but it only really works well under the 100-year-old Water Code if it's a one-to-one relationship. It doesn't work very well if it's a one-to-many relationship, because the legislature 100 years ago never envisioned a need for one water right to be pushed out to 200 different people. It was always a private transaction. I'm going to sell my farm to you, you're going to go build some houses. That was the kind of transaction that was envisioned. Go ahead. So this is this one-to-many concept where we put the water in, and what will form out of that deposit into what's called the Trust Water Right Program, which is what the State Department of Ecology runs, is you'll get a suitability map. Suitability map just means where can this water right mitigate for. If it is in a certain location, then the area right around it and everywhere generally downstream of it, it can supply that mitigation. Those are the group of you that can participate and buy shares of that of that water right. It's really not any different than if you live in the service area of a city or the service area of an irrigation district. You belong to a group of folks in an area that can be served by that water right that the county has acquired. This is another graphic that just explains the process. So before, on the left-hand side, the current situation is you have a water right that is older than the in-stream flow rule, and it is using water which has some effect on the creek, but because it's senior, first in time is first in right, it is protected against that in-stream flow rule. Then the county purchases that water right and puts it into the state trust program, and the stream flow goes up. That's $200 deposit I was referring to in my example. And then over time, as exempt wells go in and people file for their building permits and pay their fee, the stream flow goes back down, slice by slice, based on the principles Carl was talking about, until that whole water right is used up, and but the stream is still protected. Okay, so that's the concept of water banking.
What if you're a senior water right owner and you don't want to sell your water right to the county?
You don't have to.
Okay.
Yeah, good question. So the challenge here is, as I said, these suitability maps, which was that area in green that I just discussed, one size doesn't fit all. If we acquire a water right in the westernmost portion of the basin, it might not be as suitable to mitigate on the easternmost portion of the basin. It gets pretty complex, and there's a lot of hydrogeology, which is where Carl comes in. Okay, but the point is, the county's probably not going to buy one water right from a willing seller and solve all the problems. It's probably going to take several to kind of form a patchwork that will cover everybody that's needed. Okay? Okay, this is a flow chart that talks about the process. Okay? First, we identify a water right from a willing seller. We look and evaluate whether the water right is still valid. Remember, that certificate process I was talking about, relinquishment could have operated on it. So if the water right was issued for 100 acre feet 50 years ago, but the person has only been using half the water in the last 20 years, then that's all that's really valid anymore, and that's what we would buy and deposit into the bank. Okay? Then we have to go through this process to transfer that water right into the trust program and convert it, say, from an irrigation use to an in-stream flow use. And we would often use folks like the local conservancy board to make those kinds of transfers happen. Additionally, we have to negotiate with the Department of Ecology to hold that water right on our behalf and allow us to run the bank. There's a contract called a trust water agreement. I'm sure none of you would just turn over your water right to someone else, irrespective of whether it was your neighbor or ecology. You would want some protection to make sure that the water right that that person was holding for you was used correctly. Okay, so that's what that contract does. Then the county has to go ahead and adopt county code revisions. They're basically getting into a brand new area of service. They're creating a utility and marketing a product that they never had the expectation until the Hirst decision came out that they would be required to do. So there's a lot of county code stuff that needs to happen. And then lastly, there's outreach and training. Outreach to the public, training to county staff to make sure hopefully this program rolls out seamlessly. And the county's been working very hard to get this done as quickly and as painlessly as possible. Hirst just came out about 7 months ago, and the county expects to have their bank for at least a portion of the Little Spokane watershed up and running before the end of the year. Okay, it took Kittitas County 5 years to work through all that. They were first, so it was harder. Okay, but the county is doing a lot to try to bring this problem into focus and get some solution for people as quickly as possible. Okay, let's skip this. I think I already discussed that. I want to get to some questions. So what's going to be in the county code? These are some of the questions that folks may have. One of the questions is, who is the target customer for the bank? As I said in an earlier slide, the exempt well, or the permit exemption allows a whole bunch of stuff to happen. Okay? If we allow all of those things to happen under the county ordinance, then the water right we buy for all of you guys to participate in is going to get used up really quick, right? But if instead we try to mirror what your reasonable use really is, then maybe that stretches further. So there's some decisions to be made about what the product is that is even going to be sold. So if, for example, you look at folks like the water bank in Kittitas County or in the Dungeness, you can go up to the counter and you can buy from a menu of a couple different choices, 2-3 choices, and you have to fit your use, your needs within those choices. It isn't necessarily unlimited. If it was unlimited, it could be very hard to administer too, which then drives up cost. There's this question about who will the bank sell mitigation credits to? Will it only sell it to people who have a building permit and are ready to build right now? Or will it sell it to folks that may want to build in the future? Okay, so there's this trade-off between solving a emergent right now problem versus giving people security long-term about the value of their property. Those are value judgments that your county commissioners are going to work through. I talked about this. How many packages will the county offer? I'm sure a lot of people will be interested in how much will this cost. There's a study going on to try to understand what that increment of cost is. And it depends on two things. How much can we buy a water right from a willing seller? If we buy it for higher, then we got to recover more costs. And what are those packages that are going to be sold? If folks are allowed very large packages, then the cost is going to be high. If they have smaller packages, the cost is going to be lower. So a lot of these things are interrelated.
Okay. I will offer, because people probably want to know, our target is somewhere in the $2,000 to $4,000 range for someone to be able to buy the water right they need to have a single family residence.
A year?
No, just one-time charge.
Oh, one time.
One time and you're done.
For new, you mean for somebody new?
For someone new.
You're not going to charge me for my well that I'm using.
Nope.
You're trying to charge me for water that
No,
I'm
it's
using.
it's a one-time charge. You guys, the way we want to design it, we're not all totally done, but the way we want to design it is you have one experience at the building permit counter where you buy it and you walk away.
Listen up, folks.
How are you going to pay for the monitoring? The county's going to be responsible for
Part
that.
of the
They're
2000.
meter the wells.
There'll be, we can get to that. There will be no.
You know,
Our
we really
design
care
is-
about how much is this going to cost. How we got here, I don't know about anybody else. I don't really care how we got here. I read the Hirst, how we got here. What I want to know more than anything else, how much is this going to cost me? Is my property be worth anything? Am I going to have to pay county taxes on property that I can't even sell now because I'm in the Spokane
Yeah,
watershed?
same here.
That's what we care about. How we got here doesn't make a damn to me or to most of these people that are here. A lot of these are farmers that have thousands of acres out in Deer Park, and if they can't retire and sell their pieces of property, then that's what they care about. How we got here, really? We want to know how it's affecting us.
Unconstitutional. And the government is the only one who wins. Yeah.
So, you know,
Well, so we'll come back to these questions. Some we can answer, some we can't.
Yeah, so there were a few questions there, and what I guess the main thing I would say is the county's working hard to try to get those answers, and the clarity is going to come in an order of a number of months. We don't have an answer for you today to say if you went in and got a building permit, your dollar figure would be exactly this much. We don't have that answer. We don't have the final answer on the requirements for compliance. Those are things that we're negotiating right now with the Department of Ecology in that trust water agreement. So there are a lot of things in flux, but one of the reasons we have outreach at this stage is to have informed decision making so that we understand what you guys want, whether you want it to look like this or to look like this, so that we can negotiate appropriately.
we don't want the government in our back door in our water. We don't. That's what we don't want.
I appreciate that. So the question was, why is the government in our back door? So the question is, or the answer to that is, under current law, that's the way it is. You're right, there are bills before the legislature right now that may change that.
They're not going to vote on it.
That's
They've
not
already
true.
said
That's
So-
not true.
Right.
The first decision had to deal with Whatcom County. It had nothing to do with Spokane County.
And
Spokane
Spokane
County is here
out.
because of they're volunteering to be here. Walla Walla exempted out of it. Stevens County exempted out of it. Pondery County exempted out of it. This is just a way for you to get more money out of the people that live in this valley.
Wait, let's take this. Let's try to take this one at a time.
You're gonna buy fictitious water that's already there.
County be charging people that are going to be using this when you're letting the city of Spokane build thousands of apartments?
So let's try to take this one at a time. This gentleman's question was regarding whether or not the Hirst decision is of statewide significance. That's an issue each county is having to interpret and make a decision on.
Thank you.
Yeah, and
We
that's,
want to just tell the truth. We're not under the Hirst decision. We've adopted that.
No, you are under the Supreme Court decision.
No, they made it very clear, it's right here. Anybody who wants to adopt it can.
Spokane
The
County
lawsuit
doesn't
was with
have to,
Washington
just
County.
like Stevens County doesn't have, you can get a building permit in Stevens County. You can drill a well in Stevens County. Right.
You
I
can
mean, these are all, I think these are all good questions,
But
but
my
they're really
question
for
with the
a.
bank is, when you do this banking, on my farm that I have, and my well that I have, and when they do this banking, thinking that I am pulling some money out of whatever, right? Well, I'm gonna pay now to use my own well. That's what the bank, no, that's not gonna happen.
So let me be real clear about a concept of the bank, okay? So the bank is for people who want a new building permit, okay? For a new well. They're gonna build a new structure, they're doing a new use. Wait, just one second, please. Just 1 second, please. Let me answer this question first. So the bank is for new impacts on the in-stream flow rule. Okay, so if you have a well that you've been using, all right, that's not the thing that's not the service the county's providing, and that's not the thing that we think the Supreme Court has told us that we need to do. Okay, I'm sorry, ma'am, what was your question of that?
The well has been in existence since the 70s. The property's never been lived on, so the well has never been used. And now I can't sell it, even though the well is over 40 years old.
Right, so it's another good question, and as we said, there's probably 200 different unique circumstances, and I would really encourage you to work with the county to figure out what the interpretation is. What I can tell you, ma'am, is based on the previous Supreme Court cases, it's not about the well, it's about the use. Okay, so all of us couldn't have, the day before the Hirst decision came out, we couldn't all go drill wells and grandfather them in just by putting a hole in the ground. It's about using water. Unfortunately, I understand it shouldn't.
Sell the property for the last 3.
I understand, ma'am. It shouldn't seem to make a difference that one day, in my example, matter. That may seem ridiculous to folks. It's not. In 2001, the city of Roslyn was told to turn off by Yakima County Superior Court because their priority date was a few days older than the curtailment period in the Yakima Basin. Prior appropriation is a harsh mistress. First in time is first in right. It's not 3 days first in time. It's not 3 years. It's not 40 years. First in time is first in right. That's the way the law is, unless the legislature sees fit to change it.
Mike, I've been holding a question since you were first talking and you made that comment that I think applies to everyone, where you said they're not going to be turning off any pre-Hirst uses. So my question is, if this watershed was adjudicated and who has rights and what would be the standing of a pre-Hirst exempt water use? And if you sell a water right, not a right, but some kind of an interest to post-Hirst, they're going to have a right that's stronger than the pre-Hirst exemption. And I think you are lining up a head-to-head issue here under that scenario.
So you're asking about what happens when the basin is adjudicated?
I'm saying we've got pre-Hirst water right users. There are people that went out, they built, they got the exemption. They don't have a water right. They don't have a certificate. They have nothing other than this legislation allowance for years. The legislature or the Supreme Court has just changed that. So senior water rights are at the head of the pack. The exempt waters, which have been fine up until now, are just kind of sitting there. If you use this water mitigation bank for new exempt uses, they're going to have a higher right than their neighbor. And if they can show impairment, you're going to put these two groups right against
what the people will be purchasing from the higher right is the ability to not be subject to the stream flow. The stream flow is the restriction. So if a person comes in and puts a new well in, that well just has the mitigation certificate they buy authorizes them to not have to pay attention to the stream flow. It doesn't protect them. It doesn't apply in any other manner. So they did not buy a water right per se that just where it was it grants them ahead of it.
But they're going to be vested by virtue of the county.
They will be able to
holding this water right, and in the event of an adjudication where we're parsing it all out again, I think the pre-Hirst users are going to be at a big disadvantage. And that is coming because the legislature has authorized the watershed adjudication. We're just waiting for money. Can you speak to the... And I hope this isn't too above because it's right down there in what we're talking about.
So there's a lot of permutations of this, and we're learning with you guys all on how to work with it. Mike, why don't you talk about the legislation question this gentleman raised?
So currently, you've probably read that there's a bill out of the Senate, it's Senate Bill 5239, and it is the only bill that addressed the Hirst decision. It was passed out of the Senate in regular session, and it went into the House Ag Committee and was heard but never passed out. And so it just, essentially died. In the special session, the Senate has reintroduced this bill and is just sitting there for the House to take it up. And the right now, I think that there's a real disconnect between the Republican Senate and the Democratic House, as you might imagine. And the disconnect really is that the Senate wants to return it back to what it was before. Good. And that's what but the House Democrats do not necessarily want to return it back to the way before. They want some sort of other, their argument would be that they don't want to prohibit new rural residential use, but they would like to have it mitigate the impacts mitigated. So those are the two sides that are lining up, and it's gotten very complicated. There's budget negotiations going on. I know that Senator Honeyford has said, I'm not passing the capital budget until you vote on 5239, and so it's really a hot topic that's swirling around, and anybody's guess is as good as mine as far as where it goes.
How did Spokane County, because what I'm understanding from this gentleman over here, other counties opted out of this?
So the decision making was, so right now the Spokane County has a comprehensive plan. And that's what the case was about. It was a comprehensive plan of Whatcom County. And Whatcom County had a specific provisions about, here's how we issue water availability determinations, and they had very specific things they went through. And so the Supreme Court invalidated Whatcom County's, or went back to the Growth Management Hearing Board's invalidation, or returned it back to Whatcom County. I'm not sure that it was invalidated, but what happened was that they said Whatcom County's comprehensive plan is not consistent and does not meet state law. In the same decision, it said RCW 1927-097 means this. It's a Supreme Court decision that reinterpreted that state law, and that's the state law that Spokane County uses. We did not develop any sort of water availability determination provisions in our code. We said we will follow RCW 1927-097. And so when the state law changed, we are implementing RCW 19, that state building code as we understood it before, which was to evaluate physical availability, and if ecology tells us there's no legal water, then we abide by that. It changed, and now this state building code now means this, and we have to do it. And if we make decisions contrary to state law, land use decisions, then we are at risk of litigation from the people that have some harm that comes to them. If we issued you a building permit, and you went out and started drilling your well and everything, and then for whatever reason, we issued the building permit kind of contrary to state law. You went out, and you took 12 months to build your house, you drilled the well, you've got a construction loan, and you go to get your mortgage to convert out of it. By that time, maybe something has happened, and now all the lending institutions are like, you got to tell me you have legally available water for, I'm going to even take that house. In Skagit County, what has happened is, it's a little different scenario, but what has happened to 500 property owners is that they built houses knowing full well, feeling like they had done everything by the book. A Supreme Court decision came in and said, the water that you have is not legally available. And so, but nobody turned them off. But what has happened is these people have gone to sell their house, they can't sell it, they can't refinance it, they can't do anything because they have water that's not legally available. So if the county knowingly puts people in that scenario, then we're at risk. That is an interpretation from the legal team at the county and the Board of County Commissioners, and that is the direction that they went, so people would not end up in this scenario.
I understand that, but how could other counties?
I mean, you'll have to ask their prosecuting attorneys.
I mean, I don't get it. Well, I thought it was statewide.
Well, and every county is dealing with it differently. Pierce County is doing what we're doing. Okanagan County is doing the same thing. Stevens County is not, you're right.
Go ahead. Speak up.
First of all, what kind of profit income projections do you guys expect from this? And part two is who gets that income? Is it the county, state, or DOE?
The question was, what are the profit projections for the water bank, and where does that income go?
The water bank is set up as an enterprise fund, essentially a business with no profit. So we do not place any burden on people that are outside of this issue. It's where we purchase the water right, and then the funds that come in pay for the water and pay for the operation of maintaining the water bank, and that's it. There is no profit.
I have a question about the property values of the property.
Hold on, one at a time, please. One at a time, please.
Second question.
That's not exactly correct because the Water Conservancy Board said that there will be a fee that will be.
So the question was, is there going to be a fee to participate in the water bank? Yes, there will be a fee. It's a cost recovery model. That's different than profit. So the county has to recover the cost that it uses to buy and operate the bank, but it's not looking to make a profit.
But they have said already that there will be above and beyond. I mean, it's just, but the $2,000 to $4,000 per person.
I mean, it's analogous to a water department or a sewer department where the fees that they charge are come back. You know, we operate a sewer utility, and the charge that we charge the customers is to pay for the facility, the pipes, the discharge, and that's it. We don't walk away. We don't have a profit line in this facility out here. So they will operate the same.
Studies on this water bank, what are your projected reserves? In other words, how much, say, on a normal bank, you got a $1 million reserves. How far down the line before the projected growth in the county wipes you out and you're bankrupt?
We have done an analysis. It kind of depends on how much you sell to each person, but we do have a purchase.
I'm not talking about that. I'm talking about the water.
Yeah, no.
There's a finite amount of water. You get so much water in the reserve. What's your projection of how much that reserve is, and at the existing growth in the little Spokane River, how long before you're bankrupt and nobody gets water?
This is how you stop growth.
Yeah, right. So
I think
we're talking probably two different things here.
So I think I understand where you're going, sir. So right now, the county has no water to mitigate for. Not yet. Okay. When the first water right comes in, the county will say, okay, here's how much we acquired. We will look at the growth rates and we'll say we can either meet the full zoning density in that area that it could serve, or we can't. If we can, great. We could stop there and go into a different area and buy a water right to fulfill those needs. If, however, the zoning density exceeds what we can serve with that first water right, then we will stay on the market with voluntary sellers and we will buy another water right to serve that. But there will never be a situation where we are upside down in what we sell versus what we buy.
Does that then mean that if you have an area where you can't acquire water rights, that you will quit issuing building permits?
Right.
That's what has happened.
But there are other ways besides buying water rights.
Because I've heard the assessors say they're not going to reduce the taxes, even though the value of your land has gone to nothing.
That's what we need to talk about, what to do with the value of our land. If you've got 13.5 acres sitting in Deer Park in that Spokane, and it was valued at, it's valued at $60,000 to $70,000 before October, well, guess what? You can't sell that property now. It's valued at maybe $1,000 an acre. So where do we go to get the taxes lowered on the property we no longer can sell because of this?
Well, I do know that. Well, I mean, it's definitely a question for the assessor. That's their. We're the environmental services department, but
yeah. And why isn't the assessor here? Because you know that is one of the main concerns about it.
Yeah, and the other thing I do know is that state legislation was proposed that talked about this exact thing, and it said that the state county assessors are required to go revalue properties based on this decision immediately. So that was offered in the legislature. I don't know if it's gone anywhere. And then, you know, the assessor has a job that's, we don't know, you know.
Well,
I don't know what to tell you.
Well, just one more point on this. It is our hope, if we are successful, that this issue is a transitory one. That there is no long-term devaluation of property, because the bank will ensure that that property has access to mitigation water if it wants to purchase and sell.
That's
So
It can't, because you run out.
So I got.
Hold on, let me finish, please. If the bank covers the entirety of the county and there is access to mitigation water, then the property can be developed and transferred as it always has been. So if you look at banks that are more mature, Kittitas County, for example, those short-term issues that were real, okay, have diminished, and people can transact their property as normal. So it's our hope that this is a transitory issue.
So if I understand you guys have created a problem.
This
Hold on, I've been
interrupted
like
for 15 minutes.
Just let me.
Please, let him answer.
So
answer the question.
are you guys going to meter these new wells once you get the senior water rights, split them up? Are they going to be metered then for the new property, the new?
It is not the intent of Spokane County to meter wells as part of the water bank.
Why didn't you guys do this like
How are you
purpose?
gonna know that it's working the way you want it to work?
Wait until you're called on.
Okay. Do you want to take a stab at how we're establishing the water use?
Yeah, so there was a question about water use, okay? So the goal in the bank is you can either sell exactly what you think people will use and then have a whole bunch of compliance efforts to make sure that's true, okay? Or you can overestimate what their use is and not do a bunch of compliance effort because your assumptions are so conservative about what those impacts are that you don't need to manage it quite as close. Each bank, when they negotiate with Ecology, finds that sweet spot about what is right for the local custom. Our preference is to run a bank that is a little bit more generous on the packages, so that if you look at the average use across everybody that's going to use the bank, it will be basically impossible for use to exceed the bank limit. That's essentially what Ecology has already done in the Spokane Rapid Prairie Aquifer. They bought a water right and they retired it, and they said, we're going to assume that each one we issue is going to be more than what the person will likely use, and therefore we don't have to go in and look at each person's water use in a way that we would have to otherwise. So there's this trade-off between what you sell and how closely you monitor what you sell. And that's what we're negotiating. I'd love to be able to tell you today, this is exactly how it's going to work. But we're working with Ecology on that. And frankly, if we gave you a cooked solution, that wouldn't be very good public process, would it?
Okay, ma'am?
Yes. Where does the money come from that you buy somebody's property right, and who in the et cetera is going to sell their property rights?
Okay.
Water rights, sorry.
The water bank fund was established with a loan from the general fund by the commissioners, and now it's in a dedicated enterprise fund, as Mike mentioned earlier, and so that's where the funding is coming from. As we said before, it's a revenue neutral account, and the intention is that ongoing purchases of water rights will be funded by selling mitigation certificates as part of the water bank. So it's intended to be a perpetual program in that regard. With respect to who in the world is selling these, we are being contacted regularly by willing sellers of water rights, who are interested. And so these are willing sellers that we're dealing with. Next question. Yeah. Okay. Yes, ma'am.
I just want to know the phone numbers, how we reach you guys to ask our individuals.
Okay.
You had it up on the whiteboard right on the...
Yeah, we had it up on the whiteboard. We put business cards out on the table. You know, we're easily accessible. SpokaneCounty.org, water resources. You go there. Rob Lindsay's name is a contact. Mike Hermanson. We're easily contacted.
So let's go to this gentleman back here. Yep. Yep, I'm pointing at you, sir. Yep. Yep, you're in.
Okay, I'm concerned about senior water purveyors because I'm seeing them trying to expand their districts right now. They're also, we've got multiple multifamily units going around, upwards of 500. I mean, in the valley, there's 3 projects that I see all the time. There's one out by SFCC. These people don't seem to be restrained by any of your wisdoms. So where are they coming in at this? And now I know, and I'm not going to tell you where this is at, but I know for a fact that they've expanded their districts. They're trying to expand their districts because I see it on title now, where I just pulled it last week. When I pulled it 3 months ago, it was not there. And they're trying to become the water purveyor for that area, which is restricting what people are doing. These apartment complexes, you can't tell me that a guy is going to take a shower and use 5,000 or 4,000 gallons a month, but the guy 2 miles up the street with a single family residence can't get a well. But yet one of the water purveyors can supply 500 units. So there's no variance on how many people live here in the water use.
Right.
Where that water is used may be relevant to you, but I don't see where water use is going down.
So let me try to get at your question. I think I understand where you're going. So the water utilities in this area have water rights that they are growing into that predate the in-stream flow rule. Okay, so those are basically those permitted rights I talked about that you grow into over time. So if a water utility has some surplus water rights, they can either use that to infill their existing systems, or they can go through a process in state law to expand their service area. There's a separate process for that the county, it's not really the county's responsibility, it's that utility's responsibility on how they expand their service area.
Well, here, I'll just offer this, that so for the last 10 years, we've been doing this thing called watershed planning, or our last 20 years. And people, citizens, and different agencies have been sitting around a table talking about exactly what you're talking about. The inconsistencies of water law and, you know, who has water versus who can use water and all of these things. There's a lot of inconsistencies, and to say it would make sense is not accurate. It just doesn't make sense. And that's why all of this litigation is...
There are opportunities where they should be restrained by the Hirst decision as well, where you're not doing
Except they
that.
have older rights. Remember, the Hirst decision is about new uses that could
why
fit
are
the
they
in-stream flow rule.
expanding when everybody else is contracting? This is the problem.
Ma'am?
Where are their water rights? I want to repeal them.
I have 2 28-acre properties my husband and I bought, take and sell when we got ready to retire. Now, can I buy water bank rights so that I can take and sell those 2 pieces of property? Or when I sell them, can the people that buy them buy the rights?
you go ahead.
That's this issue right here that's on the board, which the county commissioners are going to put into their county code in the coming months about should people be allowed to buy credits if they want to build today or if they want to build tomorrow. And it depends a little bit on, again, whether you're trying to solve the problem for people right now or whether you're trying to provide surety for people in the long term. The answer will be coming in the next few months, and obviously I know where you stand, and you should let your voice be heard.
Yeah, well, now, if you get them, can you transfer them to the new owner?
So they will run with the land. They won't be able to be transferred to other people and other locations. But yes, the idea is the mitigation certificate is recorded with the title on that land, so that there's that surety. We're going to go with questions. So, sorry, raise your hand. Go ahead.
In the back, ma'am.
Yeah, so the question is about overlapping water banks. There are some areas of the state where you have more than one option. So right now, the way it works in Spokane County is if you always have one option available to you, and it's the original option that was offered by the legislature in 1917. Anyone can go buy their own water right and transfer it to their property. That may not be a great answer, but that's one of the options that's available. The second option is if you live in the Spokane Rapid Prairie Aquifer, you can go to the Department of Ecology and get water from their bank. If you live in the Little Spokane Basin, then by the end of this year, if you're within a certain area of that Little Spokane bank, where this water right, this first water right is going to hopefully cover, then you will be able to mitigate from this bank. Over time, the county may expand their bank, the state may expand their bank, new private utilities may come in and expand their banks. It's hard to crystal ball exactly how that future is going to look.
Sir?
Okay, so let's say this water bank thing becomes successful and the Hirst decision doesn't get reversed until, let's say, a year from now, right? What happens, let's say I paid $2,000 to $4,000 for this water bank and then it gets reversed. What happens to that money?
Have you ever seen a law come off the books?
I would file that under to be determined.
Well, one thing would be for sure, you'd be holding on to a certificate that would assure for now and into the future that you have water for your house that is senior to that in-stream flow. And you never know what's going to happen further on down the road. So I would say that and actually when we were looking at establishing this water bank, even before Hirst, part of the discussion was that there may be people in the community who would want to have greater certainty about the future legal availability of their water. And so, the notion that some people may be buying water rights through a water bank, even before they had to, in a situation like we have now, we felt, there just maybe people out there who want to do that.
I will offer, one of our consultants said to me when we were looking at water rights and trying to decide which to go after, he said, well, they're not making any more of these. And so if you can get a hold of one, I think it's going to hold its value.
You can make more of them.
Well, under state law you
Sir?
can.
Thank you, Rob. This question's for Mike, so I just want to understand, the gal next to me and the gentleman over there asked you about opting out, and I kind of heard something about Spokane County's attorneys determined, and so basically without going to the consent of the people or even having a forum and talking about it.
No, what happens is you get a court decision comes down, and the county attorneys take it and they look at it and they advise the county commissioners on what the court decision means, what the risks are about what actions you then take as a result of it, and the county commissioners, as your elected representatives, make a decision about what to do. And that is really the process, and that is what happens.
So there is an option for Spokane County to opt out.
No, there's not an opt-out. I mean, it's a risk.
Right, that's what I'm saying, to go and fight it.
There's really no fight. I mean,
You can ignore it and put our
this country was
residents
built on a fight.
in peril.
And there's a documentary on Frontline about the Bundy Ranch. They backed out from the Bureau of Land Management, and they won that fight. That's all I'm saying.
what the county commissioners were presented with all of the information, all of the risks, and this is the decision they made.
Ma'am, right there.
So from now until the bank might be established then, can you get your own hydrogeologist to maybe tell you if your proposed well might end up having an impact and get some sort of determination on your own to say that this is going to be okay?
So you're talking to the Little Spokane River Basin, you get a hydrogeologist that said your well isn't going to impact.
Not necessarily where we know that the in-stream flows are already there, but anywhere else where there's just senior rights to look at.
Oh yeah, could you do it with? So if you're looking to get a building permit, that's the time when we would look at whether you meet the ordinance. And so at that time we have the options of a setback that's just general, and then we have the aquifer specific setback. And then if that does not meet what you're looking to do, then we have the hydrogeologist report. And so those are evaluated at the time of the building permit. And so that's when that can be, because that's when the decision to issue the building permit vests.
Sir?
Where is the water permit or the water bank for the Little Spokane river flow area? What part of that? Is it close to like Deer Park, Riverside?
Oh, the water right that we purchased?
No, he's asking about where geographically the rule applies.
Where if you're going to purchase the bank in that area, a small area, where is it?
The right we purchased is north of Deer Park, about 2 miles on, I think it's Montgomery and Sherman Road. And so what we are doing, there's a water right up there, and they're irrigating 100 acres alfalfa. The person decided that they don't want to farm anymore, they want to subdivide, and so they contacted us and said, we're interested in selling this water right. When they stop pumping that water, it will have, we know this from hydrogeology, that will have an increase in flow in the rivers. And so once we determine that, what we have to do now is figure out, we've made this deposit in the river system, where can people now drill wells to take advantage of that deposit? But that takes, so kind of Deer Park and north following 395, we're pretty certain of that area, but now we have to go in and look at the outer portions and figure out what's the whole extent of that area where we can sell mitigation certificates.
Highway 2 by Riverside, actually in North Ferry.
Well, you'll have to call me and give me your parcel number and I can kind of talk you through it.
Sir?
Yes, I'm curious, if I want to go tomorrow, drill a well, what's going to cost me? I've heard $2,000 to $4,000. I think it's expensive, but that's my opinion. And how long is it going to take before I can get the permit required?
Well, the first thing is you can drill a well right now. That's the and that was part of the issue, is that people were drilling wells and the county was issuing building permits and there was nobody in the middle. And the court came in and said, county, when you issue a building permit, you got to make sure there's water for that well, even if it's drilled.
Okay, well, I guess.
But the cost
for the building permit, I guess is the question.
So for the building
permit, how long is it
permit,
going to take me to get the building permit if I want to do it? Start the process tomorrow.
well, the bank will be set up hopefully in late fall, and so then that's when we'll be able to sell the mitigation
So
certificate.
the building permit isn't going to be forthcoming very soon.
Not in the next late fall probably is where we're at.
Wait a minute. Okay. I got out of line. Ma'am, you're next. You were number 4 and then I skipped.
So how will we know when the rights are, when we can purchase? Will we be notified? This Hirst thing came in sort of through the back door and nobody knew.
Right.
How will we know when we can purchase water rights?
You can sign up on the Spokane County website. You go to the main page, and on the left-hand side, there's a icon that says Stay Informed. You click on that, and then you go to a page that has a bunch of links, but on the top it says Notify Me. And under that are mail lists, and we have established a mail list for the Hirst and Water Bank, and we intend to distribute, among other ways of distributing the information. We want to make it widely known what we're doing, but people that have called and wanted a list and everything, you can sign up for that list and we can provide information.
Okay, my question is, I have some people across the street, they have a cluster app, and it's 5 parcels. They're drilling wells right now, they're not 500 feet apart, like you're saying. They're saying they're grandfathered in these wells. There's never been anything built there, there's never been anything there, and my question is a well is there land that has grandfathered in?
So what happens with the Supreme Court decision is issued on October 6th, and there's a 20-day period before it becomes effective. That 20-day period is when, on October 26th, is when the when the decision became effective in Spokane County. So likely what they did was get a building permit before October 26th.
If they didn't, they're going to come in and they're going to be surprised because they won't get a building permit.
Okay, so my other question is, if you have senior water rights and you own property, say 20 miles away or adjacent to the property that you have the water rights on, can you transfer some of that water right to that property?
Yeah, you have to go through an administrative process with the Department of Ecology. Keith Stoffel here is from the Department of Ecology, and you would talk with them about there's a process which we are going through with water right that we are purchasing.
Okay, that was my question. Thank you.
So you establish this water bank and you start selling water rights. How will you prioritize applications for building permits?
Well, right now, I'll just tell you, right, so for this water right that we purchased, or are purchasing, and this probably won't make much, intuitive sense to you, but it's 250 acre feet. We have, for the area, we are anticipating we'll be able to sell between 500 and 1,000 of the certificates. We've actually done a build out of every buildable parcel in the area that we think it's going to serve, and it's like 1,000 parcels. If you got to 1,000 homes, it will probably never get to that because we figured out, based on zoning, exactly how many houses could go in at maximum density, and it was I think 1,014 or something like that. So we feel reasonably comfortable that with the water right we purchased, that for this particular area we'll be able to serve it pretty well.
Parcel size.
Okay.
Stevens, Ponderay, and Spokane County are talking about getting the water bank together. Will Spokane County be able to cross county lines and go buy out water rights in other counties?
Spokane County could purchase water rights in Ponderay County. Klickitat County could buy water rights in Ponderay County. As a matter of fact, I am familiar with some cherry farmers who'd like to buy water rights up in this community right now. So, yeah, that option is available. Spokane County has been working with Stevens County and Ponderay County in looking at a water bank, and that our commissioners are engaged in that process. Certainly, if we were to go up and go into another county, we would be communicating with them. So I mean, we are communicating. So.
And again, how far does the watershed go around your parts?
The water right that we purchased, or the watershed?
Well, the Spokane watershed.
All the way in the back. Yes. Hold on, just one moment.
So here's the county line, Ponderay County, Stevens County. That gives you the lay of the land. This is the watershed line.
So as far as I understand it, correct me if I'm wrong, but you can only sell water rights downstream, not upstream. Is that correct?
That is, I would say that, so the question is, can you only sell water rights downstream and not upstream? I would say it's much easier to sell them downstream than upstream. It's a little bit complicated by the fact that the in-stream flows are measured in certain reaches at certain gauges, and the cone of depression that Carl was describing earlier doesn't just reach downstream, it reaches upstream and stuff too. So it's not exactly like you described, but I would say that's a generalism that's more true than not.
I would just posit though, when we're deciding on code, keeping in mind maybe equal access to people upstream, people in counties like Ponderay and Stevens having access, so that people in that county can't just, hoard all the water rights.
Thank you.
Sir?
Yeah, it's my understanding that we as landowners can drill a well right now just for RV use, recreational use, but not use for building a house. Is that correct?
For recreational vehicle use?
No, recreational use. We can use it to hook an RV up or trailers. Put our
Well, as I understand, then there are some limitations on how long you can, occupy a trailer. But again, this resonates with the building permit.
No permit.
No, but I'm just saying that
We've been told that we can do that.
yeah.
I think what you're talking about is, can you drill a well today? Yes, you can drill a well today. Whether you can establish a beneficial use. If you're not applying for a building permit at my front yard, I don't care. You can drill that well.
Not for a couple of years down the
The
road.
question is, can you legally withdraw the water from that well? regardless, or will it establish a beneficial use, and that I can't answer for you.
Oh.
Okay, gosh, so many. Ma'am? Oh, you got blue? Yeah, right there.
The question I have is, if the water bank gets established and the owner takes advantage of that, does the 500 feet rule still apply? Because if you have a piece of property that's 5 acres, you only have 330 feet wide to begin with, and it was grandfathered in as 5 acres. So how do you possibly get 500 feet from your neighbor's well?
Well, the interim zoning ordinance that's currently in place is set up on a 3-tier schedule. You can either go in and the 500 foot is established using hydrogeologic principles. It's also an extremely conservative value. And so you can hire a hydrogeologist to go and look more specifically at your area and wells in the area. And if your hydrogeologist is willing to prepare a report and put their professional stamp on it, that a new well will not impair an existing well, the nearest existing well, greater than 10 feet of additional drawdown, as we've identified in our ordinance, then we would accept that.
So if you can't do that, can you use the well next door as a community well for that piece of property?
We're actually working on this interim ordinance, and so we've received all sorts of scenarios have been posed to us, and we're trying to work through them and figure them out. I would also offer, the 500 foot's like the easy button. If you're 500 feet away, we don't need to see anything. If you're within the other, if you're sand and gravel aquifer, which you do find a lot in the Little Spokane Basin, so the basalt is 500 feet, unfortunately, but you do have the other option. But if you're in granitic, which you find up on around Mount Spokane, 200 feet, and in sand and gravel is 100 feet.
Okay.
Yeah, it sounds like the water bank is going to supply for the properties around your park, but what about the properties along Highway 2?
Well, we have, so we are actually working on multiple water right acquisitions up in the Chattaroy area, on Green Bluff, up near Elk. So we've got multiple, and our intention is to, as quick as possible, cover as much area as possible. So we are working really hard about this. And then, this is also where the legislature comes in. Absent a full reversal, which is what, a lot of people are interested in, and then some people aren't. Another thing that might happen is that it becomes a little easier to use water rights in Deer Park over on Highway 2. And so there might be some legislative relief in that area also. But we're operating under the assumption that the legislature is not going to achieve anything. And so we are definitely working on all areas of the watershed.
Can I interject something? I'm going to give a tour. People are waiting out there to have a tour of the facility. So if any of you want to do that, I'm going to begin that. So I'm going to go ahead and do that. Just wanted to make that announcement.
Okay, ma'am? Okay.
Yes, I have a buyer that wants to buy some land that has a well on it already. Is their best process to determine whether they can actually get, can they apply for a permit if it's not in their name yet? Is that something that?
Apply for a building permit?
Yeah, what's the best process for them to find out if they will be able to get water? Just go apply?
Well, the first question is where you're located.
That's across from Micah on Highway 27.
Okay.
You can give one of us a call and we can help you out.
Okay, so what your potential client or whatever is out in the Micah area. It could be granite, it could be basalt, depending on where you are. And so that's the next step is to determine what the geology is of that area. Okay, sir.
How often is this stream flow process looked at?
The in-stream flow?
Yeah, the in-stream flow.
Well, interestingly, the in-stream flow rule, I think the last provision of it is this stream flow rule should be revisited when conditions change. It was established in 1976, and these rules are not easily undone, but they can be. There's a process for that.
Well,
It hasn't.
Earlier the comment was made that, it hasn't met stream flow for 30 of the last 40 years.
Yeah.
Right.
Maybe the wrong stream flow is on there because there's still fish in the rivers.
There's a lot of arguments about that, definitely.
Yeah.
That's something that can be brought forward. I know, and up in Calder watershed, that is an effort that they've been actively engaged in, is trying to change their in-stream flow rule. And yeah, if it changed, then everything would change.
Yeah. You got a question, sir?
Yeah, if you have a family farm and you have a family that's expanded and you have water rights that have existed since 1910 in the family, and you are wanting to divvy parts of that land up to give to your children, and you were smart enough to drill a well prior to all of this a long time ago, if I understood what you said, those wells can't draw any water until I go through this next procedure that you're talking about. So can I transfer part of my existing water rights to my family?
You may be able to do that. That would.
Who would you talk to?
Ecology, because
Ask
your
him?
because your permit is with the Department of Ecology
It all depends
for
on
that
the
well.
back pattern. You gotta come in and show us what you got. If you've got real paper, you can transfer.
Yeah, I've already checked that. There's been several issues, but the first one was 1910, and then 45 and 63, and now in the 80s.
Well, the good news is
several family members involved in this.
the good news is those first 3 dates that you selected were all senior to the in-stream flow rule, so it sounds like you've got some options.
But the wells weren't.
Oh,
It's about the use. It's about the use.
But
If the
that's what I
use-
mean, they're inactive now because we had to wait for our kids to grow up to be able to do something with them, and we were foresight enough to think about doing that. So are we punished because we did that? Do we have to go back and start all over again? And we have the water rights.
Well, you need to, like I said, if you talk to Department of College and go take your water rights in and talk about what you can do with them.
But
It is kind of an
my
individual
question
case.
about the well, because we didn't draw any water out of the well waiting for the children to get old enough. They're not. They
That
don't
might be
count now?
caught, that's part of the, when you evaluate the water rights.
I recommend that's a conversation you probably want to have outside this forum.
Yeah. I mean,
Right.
there's so many more questions, sir.
My question was, we've been told that Stevens County didn't choose to opt into this program. What percentage of the county said, like Stevens County, we're not going to do it?
Well,
What percent?
it's my understanding from Commissioner McCart at Stevens County that they recognize what the requirement is on Stevens County, but they see that as an element of their comprehensive plan, which won't be updated for another 2 years.
But my question is, how many counties are like them? What percentage of the counties are doing like they are, as opposed to what Spokane County is doing?
I'm not sure what the, so I know that Pierce County is actually more restrictive than what Spokane County has done. Okanagan County is doing something, but now they were sued by the Yakima tribes over what they were doing. I know that Whatcom County has just a total moratorium, and I know that in Snohomish and King County, they are putting on every building permit that buyer beware, good luck, if we're not assuring anything. And they basically just laid it on the people getting the building permit, and I've heard a little bit anecdotally that, lenders are kind of like,
Well, I'm hearing that like 5 counties have accepted the Hirst decision and the rest are saying not us.
Well, and it depends if you're a county with an in-stream flow rule. Not all counties have those. There's only 2, and then there was brought up about Walla Walla, I believe, and there are some in-stream flow. Walla Walla has a water bank, and then there are some that don't have in-stream flow rules, and then there's some that are just not. They don't get litigated against very much.
Well, again, my question is,
I don't know how many.
it seems like if there's 5 or 6 that are doing it, there's a lot that aren't doing it, that aren't buying into that. And we, at Spokane County, are in the minority of counties that are taking this on.
Yeah, like I said, the process was under consideration was all the information was brought to the commissioners, all the risks, all the information. They make a decision as which way to go with it. You know, I know that you can give public testimony at public hearings, and you can come and voice your opinion about that. I guess that's really where we're at with that.
Okay, we're going to do just a few more questions here. Sir, I know you've had your hand up a number of times. I'm going to give some other people an opportunity. Ma'am, go ahead.
Real quick, because Department of
I'll
Ecology
get back
and
to
the
you.
Water Department, it sounds like this is sort of a new process that Spokane's going through. Are you sitting down and setting some real clear guidelines so that each side has the same message? In other words, that all the rules match up between how the water bank wants to work, how ecology will look at the water bank, how they will look at a geologist report, and maybe guidelines for people who are going to spend the money for a geologist and then get told by ecology, oh, sorry, it's not going to work, so that they know.
So we are working definitely very closely with ecology on the water bank. The ordinance that applies that's not associated with an in-stream flow rule is a county ordinance. And so, and the Hirst decision, one of the most striking holdings of it was that the county must do this independent of Department of Ecology. And so that's the scenario. And so that's kind of what we're going on. We, of course, don't want to create a situation where we're doing two different things and not...
coordination between...
Yeah, no, we are definitely. I mean, that's why Keith is here. Yeah.
Okay, ma'am?
I just had a quick question. Where can we get a copy of the PowerPoint?
Yeah,
we'll put that on the internet.
Gosh, we've gone through reams already. There's none out on the table anymore?
There were still some out there. Where would it be on the internet?
Well, the recording will likely get posted on the internet early next week.
There's some sheets out there with links
Yeah.
where you can find it.
Okay. Sir? In the back? Straight back, sir? You.
Army Spokane basis, one step basis, is that 500-foot rule and doing well?
I think his question was, does the 500-foot setback apply in the Spokane basin as well?
The whole Spokane. Yeah, we have to, you know, just like I think another gentleman was raising the fact that, oh, if you buy this water certificate, does that mean you get to move into an area and just suck everybody dry? No, we have to, the water certificate is about stream flow, and 500 foot is about making sure that you do not impair your neighbors.
So that applies as well?
Yes. Yes.
Okay.
Sir?
How does this affect the reservations and national forests?
Reservations and national, well,
Like in tribal reservations?
Tribal reservations, yes.
Tribal reservations are
they're sovereign.
well, and the tribal influence on water law in Washington could not be understated. But not in the Little Spokane River Basin. We do not. We don't really have a tribal interest. A lot of these lawsuits that Dan went through were brought by tribes, or tribes were involved in, and so there is a strong. They have a strong interest in protecting their fishing rights, and that is what drives a lot of this water law that is statewide.
Do you think you'll be able to find enough water rights to buy to accommodate most people?
Yes.
Our challenge, quite frankly, is going to be getting water up into those tributaries, higher up into those tributaries than that feed the valley. That's going to be our challenge.
But there's another way that we are also looking at. You can do things, the whole goal is to make sure that you don't diminish the amount of water in the tributary during the summer. And you can do that by buying senior water rights, but you can also do that by creating projects where you take winter runoff and you infiltrate it into the ground. And then that water kind of builds up artificially in the ground and then discharges during the summer. So that is part of the groundwater model project that we are developing right now that will support that effort to, if we can't find water rights, that we can actually go in with projects and make that available. Mitigation.
There are engineering solutions in addition to market kinds of solutions.
Sir?
The 100 acres, I think you said north of Deer Park, that you're considering buying the water rights for, how much is that going to cost?
We are, the water rights, we made an offer and signed purchase and sale agreement for what's $2,700 an acre foot. And it's a 250 acre foot water right, so it's in the neighborhood of $650,000.
Wow. That guy's got a, so in addition to his value of his property.
I mean, he could have sold that down, like I said, cherry farmers are a winery. He might have been able to sell it for more. I mean, water rights have value. There's just no mistaking it. He has maintained that water. He has been diligently using it. And if he didn't sell it to us, he could sell it to anybody.
So it's a negotiated price.
Yeah, I mean, it's the property right.
Yeah, ma'am? You got your hand up and down.
I don't mean this to sound bad, but I just, learned from the gentleman back there, but I could drill wells. I have 3 separate parcels, and you have Otter Creek in big letters up there, okay? The confluence of the east and west branch come together on my properties. There's not a lot I can do with it. I have other things there, but I've never bothered to drill a well, because I bought it out of a family trust. Stupid choice, I could have taken money. That's beside the point. So, I have 3 separate parcels right in there. 2 of them were old farm homesteads. I think some rocks might be in the old well, but I'm not sure about that. I haven't been irrigating out of it. I can check that out. So I have 3 separate, probably get a good deal, because I know the guys who have a business there. I could probably put in 3 separate wells, because right now, my property taxes that shot way up, my land is worthless. I would like to know, do people at the assessor's office, do they understand what you're saying? Because I have really big issues with this. Now, I can pay 10, 15, I'm putting in 3 wells, so I'm probably gonna get a good deal, okay? So I put wells in, there were existing wells, but I haven't been using them, because otherwise, my land is basically worthless.
Well,
and I am not a happy camper about it, because last year I was told by the Spokane County assessor, those land taxes need to go up. Now, I want to know if they understand what you're saying, because I need those land taxes to now go down.
Yeah, no, we have spoken with the assessors and presented all of this information.
But they weren't here. Did they get it?
No, they, well, I think they get it. We've talked with them. And so the other thing is
No,
I
you didn't have a big enough room. I came early because I figured this out.
No, and the other thing is, I do know I don't know all the assessor rules, how many years you wait to do it again and reassess and everything. I do know that in Skagit County, the same thing happened, and they devalued they lowered the process, and so that is likely to happen. I don't know what the timeline is on that. There's rules and everything about that I'm not aware of. The other thing is, if you have existing homes on either of those, you might.
Well, all that's left is a couple of barns and things, but I've never leveled everything, and I'm willing to throw those rocks out. We have excavators, we have stuff, we can do this. We still have flowers there. I am not a happy camper in the least, and if I need to sell it, it's worthless.
But if with an existing, you might give us a call and we can take a look at it if you already have you've had existing domestic
I'm not
use.
gonna lie about it, they haven't been in use. I have not been irrigating, but it's 2 separate pieces, 2 separate farms, 2 separate old
Well, the
wells.
irrigating part doesn't necessarily.
Well, you're telling me it had been continuous use, and I'm not gonna lie about that. It has been.
No, here, I mean, come and get a card and call me and we can talk through it.
Sir?
Well, you talked about doing mitigation as far as public works, storing water. Is there a way to get involved in that?
So we are developing this groundwater model, which is necessary to say if we put water in here, it's going to come out here at this time. And then we will be looking at the feasibility of where we could put in these you can do wetland enhancements where you store more water in a wetland, or you can do what's called shallow aquifer recharge. And our next phase is to look at the feasibility of where we could do that. And so as we do that,
But is it, like, is there anything you can do around so they can hold water better?
Yeah, possibly. I mean, are you thinking I mean, one of the ideas is that some people on a private piece of property could put that in themselves.
Yeah. That's more,
Yeah.
I don't know if that's legal.
Yeah. Well, I don't have any specific program right now, but keep in touch.
Wow, that was it. Okay, sir.
Yeah, thank you.
Dark and then in the back.
I have a well on,
No, you, go ahead, sir.
I have a well on my property, and I hand pump water to use for camping. Is that an acceptable use? Does that constitute prior use? Or is it okay to still do that?
Oh, yeah, I mean, so to be clear, the only thing the county does is issue building permits.
Right. Yeah, if you're not seeking a building permit associated with that water use, that's not of concern to us. Sir?
At what point does rainwater become public property?
I beg your pardon?
At what point does rainwater become public property? Is it?
Well,
in other words,
I would
the question
defer
I'm
to
leading-
ecology.
The question
on
I'm
it.
leading to is
Depends on
the
if
collection of
Colorado.
rainwater legal?
So let me just try this. The state has a policy on rainwater collection and spells out rooftop collectors and how that can be used. I think the state's position is that all water is public, rainwater is part of that. So, but there's essentially a policy position that that de minimis uses don't require any kind of permit. So I would encourage you to look on if you just go onto Ecology's website and Google rainwater, you'll come up with their rainwater policy and see if that fits.
And that leads to the question, is it possible then to collect rainwater and use that as an alternative to a well?
Yes, some people are using cisterns, some people are trucking water in rural areas. There's a lot of different ways to kind of self-solve. On-site storage, this gentleman was talking about. So the county bank is not necessarily intended to be the only shop in town. If people want to self-solve, there are ways to do that.
However,
There's always howevers.
You can't get the building permit. That's not a reasonable. If you put the cistern out there and say I'm gonna bring water to it, you can't get a county building permit to build a house there, right?
That's not entirely true. What is true is we don't have a way to recognize the policy right now, and the Regional Health District is working on that, and with regard to rainwater, that's who you might want to talk to, because obviously the purity is part of that for domestic use, so.
Does my accent tell you something about rainwater? I'm from Australia. We lived 25 years on rainwater. Not a problem in the world. Triple filtration, perfectly safe. The whole country runs it.
That's the health districts.
Over here?
Okay, I was just wondering, for our 4 families that were planning on breaking ground this spring, to tell the kids when they're gonna build, because we thought maybe August was gonna be the day we can have the water rights, and now it's gonna be late fall, should I tell them they're probably not gonna be able to break ground until next spring?
That would probably be good.
And is that deer?
And if they're in the location that is probably going to be covered by.
55. And is that covered by that deer part?
Well, yeah, you'll need to contact us about, we're developing the eligibility area for that particular water right. So you'll need to contact us about that. Or we will be making it available.
So, my question, I guess, is, it may have been answered, because there's so much going on, but if our state legislature decides to do the right thing and recognize personal property rights, then you reverse this, will your Little Spokane watershed plan still supersede that, or will we go back to the way it was?
Well, that's a question for the county commissioners, but my understanding would be that they would do whatever they could under state law to return to where they were.
To give people.
I mean, I understand it was mentioned that if it's purchased the right, that may be a good thing, because we don't know what's going to happen. But if they should vote on it, it should pass, and the governor finds his part to sign the thing, will we be able to do what we could have done a year ago?
Yeah, I mean, I can't speak for what the county commissioners are going to do, but yeah, my understanding of where they probably would be at would be, yeah, they would like to, if state law allows them to do that,
I'm pretty
sure
confident they do that.
They would do it, yeah.
Yeah. Okay, really? No hands up? Oh, sir. Sorry.
I don't quite understand the idea that people in the Clinton Head area would buy water rights from up north here. Are they going to pipe the water down there?
Well, no, I mean, you don't need to pipe it because it goes down Little Spokane River, down the Columbia, and piped right there.
So they just take it out down there.
Yeah, you can move it downstream on paper because it's all connected. Really? Oh, man.
My question is, how is this impacting licensed real estate agents and brokers? Are they getting or being required to have additional training so they know what to tell their customers and clients when people want to buy and sell?
Well, we've had many presentations and such to the real estate community. It's another reason for this particular meeting. I'm not aware of any additional training or certifications that would be needed at this point.
They are getting real estate, if they, I don't know if they're required to, but they get these notices about recent legislation about what they should know and what disclosures they should make sure are there, what they should be telling their customers, and I've seen at least one for the Hirst decision that was out like.
I'm not a realtor, but they're a huge force in this and what they're doing, because it obviously affected their ability to make a living right away. So anybody that's selling raw land is
So, if I understand this correctly, the counties that are actively pursuing this have large metropolitan areas in it, correct?
Yeah. Well, Okanagan County.
So, explain how this is not a way to curb rural growth. Because now we have land that the property taxes have gone up on. We can't build a home or residence on it. We're sitting on it. The water rights have value, you said that, but it's not our value. It's not ours. You took it. You've got that value. So now, how is it that around Spokane, which is the lowest point on your map, the city itself, with no unchecked growth, and yet we're being hobbled? Because we live rural.
It's called an urban growth area. Okay. And so that actually, the cities are being checked. And then the net effect of GMA and establishing those urban growth areas is, it is devaluing property in the rural areas. And I would also agree with you that, this is an effort to curb rural growth. Yeah. And I will also say that the county didn't do this. Okay? And this was a GMA issue under growth management planning that was brought in another area of the state that changed a state RCW that we were relying on in this community as a demonstration of water going forward. When the Supreme Court unilaterally or just uniformly changed that RCW, that affected us.
So just one extra point on that. The last three Supreme Court cases that kind of really brought this into focus, the Swinomish decision, the Foster-Young decision, and the Hirst decision. In each of those cases, ecology and either the county or the city lost the case. So in each case, ecology and the city or the county were trying to do the opposite of what ended up becoming interpreted as state law. So that's just the fact pattern where this isn't a situation where the counties were trying to do a power grab or something like that. They lost all the way to the Supreme Court.
One thing that I would offer up is that within the city of Spokane, cities, and Dan made reference earlier about the town of Roslyn, and they ran out of water, and then they were instructed to turn off. It's not going to happen anytime soon in the city of Spokane. The city of Spokane currently has twice as much water available to them on paper, and it was granted to them through the process called pumps and pipe certificates, than we currently use. So the city of Spokane is sitting on top of a great deal of water, and as we call on paper. Okay, so going into the future, the city of Spokane is really holding a lot of cards with respect to water resource planning in this community going forward.
The city isn't wanting to drill wells, it's the people in the rural areas.
Yes.
And that's where the population is the smallest, and we're suffering the most.
So let me come back to one theme that I hope you guys leave with, which is it is our goal and our effort to make this a transitory problem, a short-term problem, okay? I wanted to leave you with this timeline. So the Hirst decision comes out in late 2016. By January, we'd already bought a water right, or entered into a purchase and sale agreement. We're working right now through the permitting process and the county code adoption. In late fall, as Mike said, our intent is to have this bank up and running for a portion of the Little Spokane watershed so that people in that area can start building. And then again, in 2017 to 2019, we're going to look for water rights in other areas to make sure that people in those areas can. So I understand the concern about short-term property values. I have a cabin that was told to turn off at the same time Roslyn did. I was not able to use my water at my cabin in the summer. I had to buy into a water bank called the Cabin Owners Bank in order to keep using it. Okay, it's not the same as someone's primary residence. I'm not trying to say that, but I understand about not being able to use what you want. Okay, our hope is that 3 years from now, maybe the law changes and we don't have to worry about it, or the county's adapted to that change and we're offering a service so that folks can do what they still want.
So does your cabin have a well?
It has a spring. In that case, it was all surface water was told to turn off. Roslyn took their water out of the creek. I used my water out of a spring. So there were about 1,000 cabins, church camps, RV parks, and the city of Roslyn that were all told, you guys all need to turn off or buy mitigation. And in Roslyn's case, they took some water from Spokane, a golf course there, and were able to keep using water.
So, do I understand this right? There's a moratorium in the Little Spokane River drainage on any new wells.
You can drill the well, it's the building permit.
On the water rights. There's a moratorium on water rights.
Well, water rights
until you start selling the ones that you buy, the water bank. Is that right?
Yeah, they haven't issued a new water right in Little Spokane since 1990, maybe? So no new water right permit has been issued for 25 years.
Well,
I think it's more accurate to say that there's a moratorium on building permits that would rely on a new permit-exempt well or domestic well to supply water.
A new withdrawal.
A new withdrawal. So the moratorium's on the building permit, really.
No matter the acre.
No matter the acre.
When are you going to have another one of these meetings? Because you really need to have that a sayer here. Because if I have a piece of property, it has an old well on it, which according to you guys, that has value.
Okay.
That has way more value than the undeveloped parcel next to me.
Okay.
How and when is that going to affect my taxes? That's what I want to know.
Okay, well, yeah.
Because that's huge.
This was very much a learning experience for us. We knew that there was going to be a lot of people here today. That's why we set up that screen outside for overflow. I apologize for our technical difficulties, and we weren't able to do that. We are going to have another meeting soon, and we're going to do it in a larger setting, and we'll have the assessor there, and we'll probably have commissioners there as well. Okay. The purpose of this, what we were trying to do today was we've been doing these open houses, and I'll tell you what. For the past few years, we do some open houses, and we get like 13 people sort of thing. And so this is, and we know that this is a hot topic in the community. We drastically underestimated the interest for this meeting, and I apologize for that. I'm just glad the fire marshal didn't come in. So, yeah, we're gonna do this again. Like I said, we take a lot of phone calls. And, it's a lot easier for us to address a group of people and address these questions. And we know that there's a lot of, there's frustration and those come out in these meetings as well. But, I think we answered a lot of, basic questions that people have learned from. And, we learned from other people's experiences. Yes, we're going to do it again.
Could you advertise it more profoundly in the newspaper so people know when it's coming?
Everybody should get a mailing.
Yeah, with the
Yeah,
mailing.
I wouldn't get a mailing, we just.
Yeah, well, we sent out mailers into the Little Spokane for the relatively larger parcels. And then bill stuffers went to our service area customers as well, although I'm going to guess that most people came out of Little Spokane and not out of the valley. But yeah, we'll be doing more of these. Okay, and this was a gauge for us as to what's going on in the community. So,
There's a lot for us to learn.
Mm-hmm. There's a lot for us to learn too.
Yeah.
And and this is evolving.
Yeah.
I mean, Randy, the other day, he calls us up with yet another unique situation, and we look at each other and say, gosh, you just can't make this stuff up. And, and historically speaking, I'm just going to use the term, it's been a free-for-all. If you can get water, God bless you. Well, you'd be amazed at how many different ways people are finding to get water to their places. And now it's coming up because people are coming and saying, we did this, and we did this, and this well's going over there, and then my brother did that, and then, we just can't make that. And so we're learning, and we're trying to adapt to this, and there's so many unique situations. So.
You did a good job.
You did a good job.
Thank you very much.